The National Labor Relations Commission and its labor arbiters hold an important role in resolving labor disputes in the Philippines. They were created under the Labor Code of the Philippines, which sets the rules for their creation, powers, structure, and procedures. A labor arbiter resolves labor complaints before the NLRC. What is the jurisdiction of the labor arbiter? According to Section 1, Rule 5 of the 2011 NLRC Rules of Procedure, labor arbiters shall have original and exclusive jurisdiction to hear and decide the following cases involving all workers, whether agricultural or non-agricultural. 1. Unfair labor practice cases. 2. Termination disputes. 3. If accompanied with a claim for reinstatement, those cases that workers may file involving wages, rates of pay, hours of work, and other terms and conditions of employment. 4. Claims for actual, moral, exemplary, and other forms of damages arising from the employer-employee relations. 5. Cases arising from any violation of Article 279 of the Labor Code, as amended, including questions involving the legality of strikes and lockouts. 6. Accept claims for employees' compensation, Social Security, Medicare, and maternity benefits. All other claims arising from employer-employee relations, including those of persons in domestic or household service, involving an amount exceeding 5,000 pesos regardless of whether accompanied with a claim for reinstatement. 7. Wage distortion disputes in unorganized establishments not voluntarily settled by the parties pursuant to RA 6727. 8. Enforcement of compromise agreements when there is noncompliance by any of the parties pursuant to Article 233 of the Labor Code, as amended. 9. Money claims arising out of employer-employee relationship or by virtue of any law or contract involving Filipino workers for overseas deployment, including claims for actual, moral, exemplary, and other forms of damages as provided by Section 10 of RA 8042, as amended by RA 10022, and 10 other cases as may be provided by law. Jurisdiction over unfair labor practices, or ULP cases. What are unfair labor practices? Unfair labor practices are those which interfere with the employee's right to self-organization and which may be committed either by the employer or a labor organization. Here are the unfair labor practices under the Labor Code for your reference. The following are ULP by employers. Article 259. Unfair labor practices of employers. The following are ULP by labor organizations. Article 260. Unfair labor practices of labor organizations. The labor arbiters have jurisdiction only on its civil aspect, which may include claims for actual, moral, exemplary, and other forms of damages, attorneys' fees, and other affirmative reliefs. Recovery of civil liability in the administrative proceedings shall bar recovery under the Civil Code. No criminal prosecution may be instituted without a final judgment finding that an unfair labor practice was committed. Take note. Gross violation of collective bargaining agreement is a case of unfair labor practice. Hence, labor arbiters have jurisdiction over gross violation of CBA. Requisites: gross violation of the CBA, and the violation pertains to the economic provisions of the CBA. Jurisdiction over termination disputes / illegal dismissal cases. Whether the dismissal is for just cause or authorized cause is of no consequence. The validity of the exercise of jurisdiction by the labor arbiters over illegal dismissal cases is not dependent on the kind or nature of the ground cited in support of the dismissal. According to the Supreme Court, Article 224, which defines the powers of labor arbiters, vests in the latter jurisdiction over all termination cases, whatever be the grounds given for the termination of employment. Consequently, Article 229, which provides that the decision of the labor arbiter reinstating a dismissed employee shall immediately be executory pending appeal, cannot but apply to all terminations irrespective of the grounds on which they are based. Jurisdiction over money claims. Money claims falling within the original and exclusive jurisdiction of the labor arbiters may be classified as follows. Any money claim, regardless of amount, accompanied with a claim for reinstatement, or any money claim, regardless of whether accompanied with a claim for reinstatement, exceeding the amount of 5,000 pesos per claimant. In other words, the amount should exceed 5,000 pesos in order to be under the jurisdiction of the labor arbiter. However, if the complaint is accompanied with a claim for reinstatement, then the labor arbiter shall have jurisdiction, regardless of the amount of the claim. Remember, Number 1 presupposes that it proceeds from a termination dispute. Hence, it falls within the jurisdiction of the labor arbiter. In Number 2, if the amount does not exceed 5,000 pesos, and it is not accompanied with a claim for reinstatement, then it is the regional director of the Department of Labor and Employment who has jurisdiction, provided the claim arises from employer-employee relationship. Otherwise, the regular courts have jurisdiction. Take note: except claims for employees' compensation, Social Security, Medicare, and maternity benefits, all other claims arising from employer-employee relations, including those of persons in domestic or household service, involving an amount exceeding 5,000 pesos regardless of whether accompanied with a claim for reinstatement. Also take note that the voluntary arbitrators have original and exclusive jurisdiction over money claims arising from the interpretation or implementation of the collective bargaining agreement or CBA, and those arising from the interpretation or enforcement of company personnel policies. Claims for actual, moral, exemplary, and other forms of damages arising from the employer-employee relations. The Supreme Court, in a long line of cases, recognized that labor arbiters possess original jurisdiction over claims for moral and other forms of damages in labor disputes. Cases arising from any violation of Article 279 of the Labor Code, as amended, including questions involving the legality of strikes and lockouts. In general, the labor arbiter has the power to determine questions involving the legality or illegality of a strike or a lockout upon the filing of a proper complaint and after due proceedings. Here is Article 279 of the Labor Code for your reference. Disputes involving legislated wage increases and wage distortion disputes in unorganized establishments not voluntarily settled by the parties. Where the application of any prescribed wage increase by virtue of a law or wage order issued by any regional board results in distortions of the wage structure within an establishment, the employer and the union shall negotiate to correct the distortions. Any dispute arising from wage distortions shall be resolved through the grievance procedure under their collective bargaining agreement and, if it remains unresolved, through voluntary arbitration. Unless otherwise agreed by the parties in writing, such dispute shall be decided by the voluntary arbitrators within 10 calendar days from the time said dispute was referred to voluntary arbitration. In cases where there are no collective agreements or recognized labor unions, the employers and workers shall endeavor to correct such distortions. Any dispute arising therefrom shall be settled through the NCMB and, if it remains unresolved after 10 calendar days of conciliation, shall be referred to the appropriate branch of the NLRC. Where the application of the increases in the wage rates under this section results in distortions as defined under existing laws in the wage structure within an establishment and gives rise to a dispute therein, such dispute shall first be settled voluntarily between the parties, and in the event of a deadlock, the same shall be finally resolved through compulsory arbitration by the regional branches of the NLRC having jurisdiction over the workplace. Enforcement of compromise agreements when there is noncompliance by any of the parties pursuant to Article 233 of the Labor Code, as amended. Article 233. Compromise agreements. Any compromise settlement, including those involving labor standard laws, voluntarily agreed upon by the parties with the assistance of the Bureau or the Regional Office of the Department of Labor, shall be final and binding upon the parties. The National Labor Relations Commission or any court shall not assume jurisdiction over issues involved therein except in case of noncompliance thereof, or if there is prima facie evidence that the settlement was obtained through fraud, misrepresentation, or coercion. Money claims arising out of employer-employee relationship or by virtue of any law or contract involving Filipino workers for overseas deployment, including claims for actual, moral, exemplary, and other forms of damages as provided by Section 10 of RA 8042, as amended by RA 10022. Section 10. Money claims. Notwithstanding any provision of law to the contrary, the labor arbiters of the NLRC shall have the original and exclusive jurisdiction to hear and decide, within 90 calendar days after the filing of the complaint, the claims arising out of an employer-employee relationship or by virtue of any law or contract involving Filipino workers for overseas deployment, including claims for actual, moral, exemplary, and other forms of damages. Consistent with this mandate, the NLRC shall endeavor to update and keep abreast with the developments in the global services industry. Other cases as may be provided by law, such as contested cases under the exception clause in Article 128 paragraph B of the Labor Code. Issuance of writ of execution to enforce decisions of voluntary arbitrators or panel of voluntary arbitrators in case of their absence or incapacity for any reason. Contested cases under the exception clause in Article 128 paragraph B of the Labor Code. Notwithstanding the provisions of Articles 129 and 224 of this code to the contrary, and in cases where the relationship of employer-employee still exists, the Secretary of Labor and Employment or his duly authorized representatives shall have the power to issue compliance orders to give effect to the labor standards provisions of this code and other labor legislation based on the findings of labor employment and enforcement officers or industrial safety engineers made in the course of inspection. The Secretary or his duly authorized representative shall issue writs of execution to the appropriate authority for the enforcement of their orders, except in cases where the employer contests the findings of the labor employment and enforcement officer and raises issues supported by documentary proofs, which were not considered in the course of inspection. If the exception applies, the RD must endorse the case to the labor arbiters of the NLRC. In order to divest the RD or his representatives of jurisdiction, the following elements must be present. 1. That the employer contests the findings of the labor regulations officer and raises issues thereon. 2. That in order to resolve such issues, there is a need to examine evidentiary matters. 3. That such matters are not verifiable in the normal course of inspection. And 4. That the employer shall raise such objections during the hearing of the case or at any time after receipt of the notice of inspection results. Issuance of writ of execution to enforce decisions of voluntary arbitrators or panel of voluntary arbitrators in case of their absence or incapacity for any reason. Article 276 of the Labor Code states that, upon motion of any interested party, the voluntary arbitrator or panel of voluntary arbitrators or the labor arbiter in the region where the movement resides, in case of the absence or incapacity of the voluntary arbitrator or panel of voluntary arbitrators, for any reason, may issue a writ of execution requiring either the sheriff of the commission or regular courts or any public official whom the parties may designate in the submission agreement to execute the final decision, order, or award. Take note. These are some of the cases over which labor arbiters have jurisdiction as recognized in jurisprudence. Employees in a GOCC without original charter, alien parties, priests and ministers, if the issue involves a labor dispute or case, employees who are not members of cooperatives, and counterclaims of employers against employees. The following are excluded from the labor arbiter's jurisdiction. 1. Assumption of jurisdiction by the Dole Secretary or the President. 2. Compulsory arbitration by the NLRC. 3. Cases arising from the interpretation or implementation of collective bargaining agreements and those arising from the interpretation or enforcement of the company personnel policies shall be disposed by the labor arbiter by referring the same to the grievance machinery and voluntary arbitration as may be provided in said agreements. 4. Voluntary arbitration agreed upon by the parties. Take note. Cases under the jurisdiction of the labor arbiter may be the subject of voluntary arbitration before a voluntary arbitrator with the consent of both parties. As mandated by the 1987 Constitution, the state shall promote the principle of shared responsibility between workers and employers and the preferential use of voluntary modes in settling disputes, including conciliation, and shall enforce their mutual compliance therewith to foster industrial peace. 5. The visitorial and enforcement powers of the Dole Regional Director to order and enforce compliance with labor standard laws can be exercised even where the individual claim exceeds 5,000 pesos. While it is true that under Articles 129 and 217 of the Labor Code, the labor arbiter has jurisdiction to hear and decide cases where the aggregate money claims of each employee exceeds 5,000 pesos. Said provisions of law do not contemplate nor cover the visitorial and enforcement powers of the Secretary of Labor or his duly authorized representatives. 6. Corporate officers for intracorporate controversies. One who is included in the bylaws of a corporation in its roster of corporate officers is an officer of said corporation and not a mere employee. The determination of the rights of a corporate officer dismissed from his employment, as well as the corresponding liability of a corporation, if any, is an intracorporate dispute subject to the jurisdiction of the regular courts. The regional trial courts exercise exclusive jurisdiction over all controversies in the election or appointment of directors, trustees, officers, or managers of corporations, partnerships, or associations. Venue. All cases which labor arbiters have authority to hear and decide may be filed in the regional arbitration branch, having jurisdiction over the workplace of the complainant or petitioner. For purposes of venue, the workplace shall be understood as the place or locality where the employee is regularly assigned at the time the cause of action arose. It shall include the place where the employee is supposed to report back after a temporary detail, assignment, or travel. In case of field employees, as well as ambulant or itinerant workers, their workplace is where they are regularly assigned, or where they are supposed to regularly receive their salaries and wages or work instructions from, and report the results of their assignment to their employers. Rules on venue. Where two or more regional arbitration branches have jurisdiction over the workplace of the complainant or petitioner, the branch that first acquired jurisdiction over the case shall exclude the others. When venue is not objected to before the first scheduled mandatory conference, such issue shall be deemed waived. The venue of an action may be changed or transferred to a different regional arbitration branch other than where the complaint was filed by written agreement of the parties or when the commission or labor arbiter before whom the case is pending so orders, upon motion by the proper party in meritorious cases. Cases involving overseas Filipino workers may be filed before the regional arbitration branch having jurisdiction over the place where the complainant resides or where the principal office of any of the respondents is situated, at the option of the complainant. Powers of the Labor Arbiter. The Labor Arbiter has the following powers. 1. Adjudicatory power. 2. Contempt power. 3. To conduct ocular inspection. 4. To issue writs of execution, including enforcement of voluntary arbitration decision in case of absence or incapacity of the voluntary arbitrator or panel of voluntary arbitrators. 5. To declare legality/illegality of a strike or lockout. Reinstatement and or execution pending appeal. Order of reinstatement by the labor arbiter is immediately executory. The execution is not stayed by an appeal. The employer is required to submit a report of compliance within 10 calendar days from receipt of said decision. Reinstatement. Reinstatement may either be 1. Physical or actual reinstatement, or 2. Payroll reinstatement. In any event, the decision of the labor arbiter reinstating a dismissed or separated employee, insofar as the reinstatement aspect is concerned, shall immediately be executory, even pending appeal. The employee shall either be admitted back to work under the same terms and conditions prevailing prior to his dismissal or separation, or, at the option of the employer, merely reinstated in the payroll. What is the effect of noncompliance? If disobeyed, the labor arbiter shall immediately issue a writ of execution, even pending appeal, directing the employer to immediately reinstate the dismissed employee either physically or in the payroll, and to pay the accrued salaries as a consequence of such non-reinstatement in the amount specified in the decision. The labor arbiter shall motu proprio issue a corresponding writ to satisfy the reinstatement wages as they accrue until actual reinstatement or reversal of the order of reinstatement. The sheriff shall serve the writ of execution upon the employer or any other person required by law to obey the same. If he or she disobeys, such employer/person may be cited for contempt. Reinstatement wages pending appeal, exempt from restitution. Where the executed judgment is totally or partially reversed or annulled by the Court of Appeals or the Supreme Court with finality and restitution is so ordered, the labor arbiter shall, on motion, issue such order of restitution of the executed award, except reinstatement wages paid pending appeal. If the employee has been reinstated during the appeal period and such reinstatement order is reversed with finality, the employee is not required to reimburse whatever salary he received, for he is entitled to such, more so if he actually rendered services during the period. Order of reinstatement by the NLRC, Court of Appeals, or Supreme Court. Unlike the labor arbiter's order of reinstatement, which is immediately executory, the order of reinstatement by appellate courts such as the NLRC, Court of Appeals, or the Supreme Court is not immediately executory and thus requires a writ of execution.